Ladies and gentlemen, online viewers worldwide, welcome to the 2020 Tang Prize Laureate Lecture in Rule of Law. The 2020 Tang Prize in Rule of Law is shared by 3 non-governmental organizations. They work in different areas of the world, but share the virtues of promoting the rule of law where it faces severe challenges. Today, we're honored to invite the 3 laureates to share with us their experiences. May I now invite Dr. Ye Junrong, Chair of the Tang Prize Selection Committee for Rule of Law, to introduce the 2020 Tang Prize Laureate. Dr. Ye, please.
Ladies and gentlemen, the 2020 Tang Prize in Rule of Law is special in that it was jointly awarded to 3 international non-governmental organizations. Each of them has made remarkable efforts in advancing the rule of law in their respective societies, overcoming the challenges unique in their surroundings. One common approach shared by all 3 organizations is strategic litigation. That is, instituting legal proceedings aiming at crowning rulings of the court so as to bring about progressive changes. That is the common theme in this series of laureate lectures. How does a group of citizens advocate for social change in a society under autocratic rules where the channels of democratic changes are suppressed and the political institutions are not functioning well? Those are circumstances faced by the legal agenda in Lebanon, and also prevalent in many countries in Arab-speaking world and beyond. The real possibility for change found by legal agenda lies in the court, for the reason that the court is not dominated by politics, and progressive arguments can be raised and considered in the facade of legal technicalities. In this lecture, you will hear how the legal agenda fights for human rights through litigation, and based on its success, how the legal agenda further worked in furthering the strategic litigation by initiating the formation of judges association and developing model defense to be widely utilized by activist groups in the Arab world. The experiences of the legal agenda on strategic litigation will be shared by Summer Grongrong, who is a member of the General Assembly of the Legal Agenda. The title of the speech is Public Interest Litigation in Undemocratic Arab Context, Lessons from the Legal Agenda Experiences. Summer, the floor is yours.
Hi, I am Samer Ghamroun. I am one of the co-founders of the Legal Agenda since 2009 here in Beirut. I am also the head of the Socio-Legal Research Department in Legal Agenda, and I am an assistant professor in Law and Society at the St. Joseph Law School, St. Joseph University here in Beirut. So let me just emphasize at the beginning how much we are proud and honored at the Legal Agenda to be one of the recipients of the prestigious Tang Prize for the Rule of Law category. We are very proud because we are aware how distinguished is the Tang Prize and how it will help us in the future to promote the rule of law and rule of law principles in the difficult region which is the Middle East, where we work. As most of you know today, or some of you at least, the Legal Agenda works in Arab-speaking countries on issues of law and society related to many questions like the independence of the judiciary, social justice, equality, fundamental rights and freedoms, rights of vulnerable groups, and so on, and other issues. And in all these issues, litigation and public interest litigation is a very important, a key element in promoting these principles and these rights we are talking about. I want to state and I want to emphasize how much our work on the ground, the Legal Agenda's work on the ground, has allowed us to identify specific challenges for the issues of the rule of law that might not be identified by scholars or academics. And these challenges allowed us to ask new questions and interrogations about the implementation and promotion of these rule of law principles through litigation mainly. So after years of work in courts with judges, with lawyers, with law students on the ground in Lebanon, Tunisia, Egypt, and other Arab countries, Arab-speaking countries, we started searching what does it mean to work for the rule of law in a region where law is often a brutal tool in the hands of autocrats of all sorts. When we are facing actually not a rule of law, but actually a rule by law system. And most of you know this distinction between rule of law and rule by law, and in the latter, rule by law, law is just a tool, a weapon in the hands of dominant groups in government or the establishment, allowing them to control and repress people and groups in society. So what does it mean when to litigate? What does public interest litigation means in context of rule by law, which is the context, as we will see, of most Arab-speaking countries? And how can litigation produce social progress and legal change when courts are, as they are in most Arab-speaking countries, dependent on autocratic or corrupt rulers and autocratic and corrupt establishment groups which dominate the polities of these countries, and especially in a period where the COVID pandemic has allowed these autocratic governments in the region to gave it pretext to kill social mobilizations and street mobilizations in the region. So, with these questions, we must be aware that these questions are necessary because of the context in which we work, the context of rule by law and the absence of democracy in most Arab-speaking countries. Let me give you a few examples. Like if you go Syria, Libya, Yemen, you have collapsing institutions with often a war situation. In the Gulf countries, you have autocratic rules with a political economy which is very repressive and unfriendly to fundamental rights and freedoms. You have a big concentration of power in traditional monarchies like Jordan or Morocco. You have different kind of authoritarianism in Egypt, or even different in Algeria. You have very unstable situations in Iraq, in Sudan, and today in Lebanon with its huge economic and political crisis. You have Israeli occupation and apartheid in Palestine. And the only country which might show positive signs on the level of rule of law and democracy, Tunisia, is facing very difficult challenges in political and economic issues today. So we have a region, we are talking about public interest litigation in a region where crony capitalism and authoritarianism in its different forms often hide behind nice constitutional facades, often parliamentarian facades, or even constitutional monarchies. But these facades and these covers are hiding very violent, repressive, and control practices in most Arab-speaking countries, with the partial exception of Tunisia, as we said. So we are in a region where law is often a repressive, exploitative tool in the hands of autocrats, and where courts, where we are going to litigate, are often an element of the control apparatus of these autocratic regimes. So basically, what we must be aware of is that we don't have much choice, practically, than to go to courts. Why? Because other aspects of the political scene and the social scene are totally paralyzed by the repressive and autocratic regimes in place. Like we have in all these countries, most of these countries, we have rigged electoral processes when there are elections, which isn't the case in many Arab countries. Rigged electoral processes, think of Lebanon, partially think of Egypt and other countries. We have repression and intimidation through army, police force, intelligence apparatus, and courts are often a main part of this repressive apparatus. You can think of many Arab examples also. You have a failed party system. Political parties, when they exist, are just a cover for other centers of power, other leaderships which do not need the parties actually to exert their power. Professional representation is often dysfunctional, despite the exceptions we saw recently in Sudan or in Algeria maybe, but mainly professional representation and unions remain totally dysfunctional and controlled by power. And of course, a dysfunctional mediatic scene where the media is just a mirror of the establishment and the autocratic regime. So it is nearly impossible or very difficult to achieve social change via traditional politics, electoral politics, parliamentarian politics in most Arab countries. So basically, when we observe this very grim, very difficult political situation, where elections are often controlled and rigged by the regime, and where the conditions of a national political public debate are not met because of the control of the media, of unions and NGOs, and etc., litigation can become, and this is my point today in this short presentation, litigation can become one of the rare tools available to initiate public debates and social change, as we will see. To initiate public debates about rights issues, freedom issues, in such very unfavorable contexts as the Arab-speaking countries we spoke about. So, of course, when we say like public interest litigation or strategic litigation, many, especially in academia, many might have a very skeptical view of this tool, because part of the Western literature has shown that public interest litigation can be a depoliticizing machine. Why depoliticizing? Because mainly through going to courts, it technicizes the debates, it transforms public, national, democratic debates into technical legal debates, which excludes all the citizens who are not specialists, which means most of the population. So technicalities, technicizes the debate. It convinces people, according to these critics of public interest litigation in the West, it convinces people to leave the street and to leave political demands as formulated in demonstrations, in other kinds of street politics, to leave it and to rely on lawyers and courts and legal demands which would be more comfortable for autocratic regimes. It's always more comfortable to deal with a legal argument in a court which is not independent anyway than to deal with thousands of people in the street. And third, public interest litigation, according to this critical literature, offers people fake victories and hollow hopes, because judicial victories are often an illusion, are often ignored by political actors or circumvented by political actors. So it gives a fake sense of victory to social actors when they win a case, while it's the effect of this victory on the effective balance of power is very limited. So in contexts like those of most Arab-speaking countries, public interest litigations, and I argue here, as others have maybe, public interest litigations can play a very different role. in an opposed way, in a different way from the Western democratic or democratic context, even if they are not in the West. But in such context, where the political system is totally blocked and controlled by an extreme concentration of power in politics, economy, etc., litigation, when carefully designed and built, as I will explain, is not an apolitical tool. It's a politicizing tool in a very healthy way, as I will show. So from a pragmatic perspective, for lawyers, activists who work on the ground in these Arab-speaking countries, courts and litigations can be a way, under certain conditions, can be a way to repoliticize an otherwise static social scene. Static social scene that we find in most Arab-speaking countries today, political scene, I mean, the society is never static, but political scene, the visible official political scene in these countries can look static because of repression, because of cooptation, because also sometimes of crippling meta-debates. What I mean by meta-debates is huge debates that totally monopolizes public debate in a country, like the secular religious debate in Lebanon or in Tunisia lately, the West versus East debate, as we're observing it in some countries also in the Middle East. So these huge debates annihilate the possibility of politics, meaning of debating the actual lives of people in these countries. So litigation in these contexts allows sometimes to reintroduce debates into daily life and about daily life. So debate about issues that concern the lives and freedoms and rights and of citizens in these countries. So litigation, under certain conditions, can become a subversion, a way to repoliticize public space when traditional politics have been hallowed, emptied by crony capitalism, biased media, rigged elections, and so on. So it is a way to revitalize politics. And that's why we developed this tool from the beginning in Legal Agenda, and we have been conducting more than 50 cases of public interest litigations, different cases, mainly in Lebanon until now, even if we plan to develop it elsewhere in the next few years, and related to many issues, since like LGBTQ, in a way, for example, to reinterpret criminal law and to reinterpret the notion of nature in criminal law, to encourage judges and lawyers to understand nature in a different way, as a way not to repress sexual freedoms, in issues and cases of labor law, in order to consolidate the rights to form unions for workers, for example, in issues of migrant workers, in order to put an end to a discriminatory and abusive legal situations for migrant workers in Lebanon, but also many other issues related to freedom of expression, access to information, protection of the environment, reclamation of public domain, human trafficking, refugees, handicapped persons, sexual harassment, protesters' rights, and other issues. And you might notice that many of these issues are unpopular issues. What I mean is that it's not just repression and political obstacles, meaning government, that complicate working on these rights and issues. It's also a general popular resentment on like refugee issues or LGBT issues, etc., which means that litigations in these cases can become even more complicated, facing even more pressure from the ground. Not only the political regime, but also normal people who might wonder why we are litigating for migrant workers, for refugees, human trafficking or LGBTQ, etc. So what I want to emphasize here that the main battle is not a legal one in public interest litigation, in undemocratic contexts like in the Arab-speaking countries. It is not just a legal battle. It's not about selecting the right cases, producing the right legal arguments or precedents, like it is in most cases of strategic litigation everywhere in the world. It is, especially here in these unfavorable contexts, a matter of a normative battle. Normative battle meaning to change the normative and professional environment of legal professionals, of lawyers and judges and law students also in these countries. So I will try to state two things in this very short presentation. I've started to do it, of course, since 10 minutes. First, that public interest litigation can have a politicizing effect in undemocratic contexts, unlike what many authors claim in the West or in other democratic contexts. And second, that public interest litigation needs specific conditions to be possible. We know this, but what's more interesting is that we can create these conditions in unfavorable context. Intelligent activism can produce these conditions even in the hardest circumstances like the ones we are facing in the Middle East. So we are able, through litigation, to produce a very healthy politicization, politics, which the regimes is forbidding. The regimes doesn't let us do real politics in the streets, into public space and media. Litigation can be a wonderful tool to reimpose other kinds of politics on the regime and in the public debate. Now, how do we create these conditions of possibility of public interest litigations in these undemocratic contexts in the Arab-speaking countries? The first condition to create concerns a different kind of judges. We know today, and without getting into the technicalities of it, but the judges and judiciary has two faces. One face is the face of power. Courts and judges are part of the control apparatus on society, anywhere in the world. But the other face of the judges and of the judge is the face of an actor that can go against power, against executive or legislative power. And our goal here, as researchers, activists, lawyers, is to encourage this second phase of the judge in our countries. And our goal is to, which is essential to any public interest litigation effort, is to develop this second aspect of the judiciary. And to give you an example of what it practically means, here in Lebanon, for a long time, judges didn't have the right to unite in an association. Judges' clubs or judges' associations were forbidden. We started, since 2007, 2008, 2009, we started working with many judges, trying to present the idea and the importance of judges' associations. We made comparative research trying to show how a judges' association can help judges better protect their independence and their integrity, better be more vocal about the dangers on their professional practice, and so on. But during these years, in the absence of judges' associations, the only voice in the judiciary was the High Judicial Council in Lebanon, which is totally or mostly, depending on the years, mostly whose members are mostly chosen by the executive power. So as long as we didn't have judges' association in Lebanon, executive power was speaking in the mouth of the highest ranking judges in the High Judicial Council. So we had to work for more than 10 years, 12 years approximately, with seminars, articles, workshops, discussions. We put together judges from Tunisia, Morocco, Egypt, because they have very active, or had very active judges' associations and clubs there, with Lebanese judges, trying to introduce this idea and its importance, because we were convinced that as long as the only voice in the judiciary was the High Judicial Council, we won't get anywhere towards the independence of the judiciary and towards effective public interest litigation. Because without sensitive judges to social issues, you cannot do public interest litigation. And finally, in 2018, 3 years ago, this Judges Association was created in Lebanon after years of discussions and despite the repressive and the repressive attitude of the judicial hierarchy, of the High Judicial Council, which was totally refusing the idea of a Judges Association. Why? Because these are the two faces of the judges I started talking about. There's the face of power represented by the High Judicial Council, and the other face of not necessarily against power, but more distant to power, which is the Judges Association. So we succeeded in encouraging, with other people, of course, other associations, and the judges themselves, they created these Judges Associations, which gave a voice to this second phase of the judiciary. And it is very important to encourage judges to leave their very conservative role. Like the Egyptian model, the Egyptian experience was very useful to us here, because we showed other judges in the Arab-speaking countries, we showed them that how Egyptian judges, especially in 2005, 2006, understood that under the authoritarian regime that was prevailing then, the Mubarak regime, it was impossible for judges to really perform their duty while remaining in their traditional role, like merely and only implementing the law. So Egyptian judges in 2005, 2006 showed that they had to politicize their action. Politicize meaning not to go with this political party or this one, but to intervene, go into the public debate on issues important for judicial independence and impartiality. Egyptian judges showed us, other judges in the Arab countries, showed them that in such authoritarian context or undemocratic context, it is not possible to remain in the traditional conservative role. Judges had to invent a new social role for themselves. And we tried as much as possible to introduce these questionings, and other people have been trying to introduce these questionings into the circles of judges. Like, what is the social and political function of judges? What is their role in society, in our society, not in general? Is this role to blindly implement repressive laws that are produced by undemocratically elected assemblies, like they are in most Arab countries, or to work towards more substantial notions and forms of justice? When these questions become dominant in judges' circles, public interest litigation becomes much more feasible. When the second phase of the judge becomes dominant, or at least become visible, the face of the judge who can be critical towards the executive and legislative power, towards dominant parties in society, when this face becomes dominant, public interest litigation becomes more feasible and possible in all other issues. LGBTQ, refugees, vulnerable groups, workers, domestic violence, all issues become within reach. Why? Because we start to have a judiciary in its society, judges in their society, not above their society, as the power regimes want them to be. So, first condition to kind of subvert or change the judicial scene. The second condition is to do the same things, but on the lawyer scenes, because lawyers also have two faces. A liberal face, a traditional face, let's name it, the liberal traditional face, where the lawyer defends the interests of his clients only, and where the criteria of his success or her success and failure is measured through financial milestones mainly. A successful lawyer is a lawyer who has among his or her clients much more big companies, banks, and so on. Of course, the other face, I'm simplifying a lot, but the other face of the lawyer is a lawyer, like we can call them cause lawyers or public interest lawyers, are lawyers who are much more mainly committed to promoting social issues and defending social causes and very important causes like the different kinds of rights we've been talking about. So it is very important, before engaging in public interest litigation, to promote this different kind of lawyering. And this is even more difficult than judges. Why? Because in our political economies in the Arab-speaking countries today, especially after the liberalization phase in the 80s and the 90s, in our new political economies, lawyers are encouraged to side with the most powerful actors in society because their success, a successful lawyer, is evaluated on this criteria. So how to promote another kind of lawyering? Of course, here we worked on the tools, we worked on giving an example of different kinds of lawyering in our countries. The tools, let me give you 2 examples. For example, what I call the media issue. Traditionally here in Lebanon, lawyers shouldn't go onto the media to speak about their cases. It is forbidden for a lawyer to go on media and start speaking about a case he's defending. Of course, while in traditional lawyering this can be explained, I don't have the time to explain it now, but it can be explained because in the interest of the clients, of other lawyers, and so on. In these new kinds of lawyering, it was totally unimaginable to forbid lawyers to go to the media. Why? Because they are defending public causes. They are defending causes where there is a strong party and a weak party, where there's a dominant and a dominated. So media is crucial here to promote these just causes, these causes that this different kind of lawyering is carrying. So one of the battles has been, in the Lebanese context, for example, to allow lawyers, when they are defending big public interest issues, environment, corruption, and so on, to be able to go to the media, because otherwise the dominant party will always be dominant, and it would be impossible to change anything. So it was very relevant to make a change in the normative environment of the lawyers, especially in relation to these media issues. Another example, for example, about the tools, we developed model defenses that elaborate legal arguments to defend marginalized groups. These model defenses can, of course, fill the gaps in litigation when defense lawyers are still beginners or have no budgeted time to make their own work and research. Or even when lawyers are available, judges can use these model defenses as a pleading example. And these model defenses contribute to a discourse that help victims understand their legitimacy towards the judge. So on the main issues we were working on and doing litigation on, we developed these model defenses, documents showing how these cases should be defended, and disseminated them between lawyers, judges, to show how a specific kind of argumentation, of legal, socio-legal argumentation, can be made to better defend these cases. So these are examples of the tools, but also an example should be given to lawyers in these countries, an example they can follow. For example, in the Lebanese case, of course, I know the most, in 2015, there were many protests in Lebanon about the garbage crisis, and a lawyers' committee to defend the protesters was created in 2015. And these were volunteer-based lawyers. These were volunteers that were defending the protesters that were arrested in these demonstrations. And this committee started giving a unique experience for the entire profession in Lebanon and other countries, entire legal practice body in Lebanon, showing them how lawyering can be different, how it cannot be reduced to a relation between a lawyer and a client, often a wealthy one. And this 2015 experience was reactivated in 2019 following the big protests against the regime in Lebanon at the end of 2019, the uprising. And here again, we saw even more and more lawyers, volunteer lawyers, coming to defend the protesters, which indicates between 2015 and 2019-20 and today, which is indicating the changing values and norm inside the legal professions and the lawyer's profession in Lebanon. So we're trying to develop a role for lawyers in their society beyond their classical defense of freedom. Condition 3 is, of course, legal education. Here I should be very fast, but also legal education and legal curriculum in law school remains very conservative in its definition of what law is, what a legal professional is, and so on. Law is presented until today mainly as a technical science versus the law and society and the law in society approach we are defending. And no public interest litigation can be developed from this. So it is very important also to work on the levels of law faculties and law departments, as we did in Lebanon, but also Tunisia, to propose new courses in relation to law and society, the political dimensions of law, legal sociology, legal anthropology, legal history, to develop the critical approach to law in law students. And then to introduce new material even in traditional courses, like new case studies in contract laws, new issues in administrative law, and so on. And then change bibliographies and syllabuses to propose new texts and references. Basically, to enter the curriculum and to change it from within in order to produce in the future different kinds of legal professionals. And of course, trying to propose also different training possibilities for law students. For example, alternative experiences to familiarize them with public interest litigation, like internships in litigation and so on, but also to offer them new professional role models, as we've seen for law students, the judges and lawyers in their societies, not above their society. And finally, condition number 4, help establish a new media environment more sensitive to rights issue. And of course, traditional media in the region, in public Arab-speaking countries, fail to offer a proper environment for public interest litigation because it often follows political actors in their definition of what should be talked about or what should be covered. The definition of the issues to be reported remain constrained by the limits of the political system. And then we have often in traditional media the lack of legal and judicial culture, which produces often irrelevant reporting, which covers sensational aspects of trials instead of focusing on the most important and relevant ones. So it is very important to create a parallel or a different media environment to go with public interest litigation. Independent media, specialized media that understand law and the functioning of the judiciary and is able to follow cases in courts in a relevant way and to formulate issues outside the dominant political agenda. Issues related to the independence of judiciary, independence of judges, legislation, and so on. And this new, different media environment is obviously one of the best allies for successful public interest litigation because it sensitizes the public to the importance of litigated cases, issues, and the potential decisions and what can be made of them. So, at the end, to conclude, because I think I've been beyond my time, public interest litigation, as I've already said, produces a new kind of politics in undemocratic contexts. In these weakly or undemocratic contexts, it becomes possible to do this kind of public interest litigation, but only through this multi-level work on all the aspects we talked about: judges, lawyers, media, law schools, and so on. And this litigation that can be created through these conditions I talked about is a strong politicizing and vitalizing drive in societies like Lebanon, but other Arab-speaking societies, where the traditional tools to make social or legal change are often hijacked by powerful interests in governments or in the economy. And I can give you many examples on this healthy politicizing effect we're talking about today. Litigation on LGBTQ plus rights in Lebanon and other countries, and the public debate that was created around it, allowed the public to get aware of how the control of bodies and of sexuality is just another face of the political control and repression in our societies today. Litigation on the rights to know what happened to the disappeared persons of the Lebanese civil war, for example, allowed the public to know how the political establishment has been manipulating collective memory in order to control the present and the future in Lebanon, and similar in other Arab countries who have known difficult and war past. Litigation on workers' rights and the debate around it, and public debate, allowed people and the public to be aware that the repression of workers in industries and companies and so on was only mirroring the repression of citizens in the public space. And to know more also about the alliance between many big investors and businessmen and women and the main Lebanese politicians in the political class. So judicial processes, in these cases and many others, were formidable pedagogical tools to show how previously seen technical legal issues actually hold a huge political dimension and importance for the present and the future of our societies. Of course, judicial decisions alone cannot produce concrete social change immediately, we all know that, but in our case, these judicial decisions have been solid bridges towards more ambitious and even more radical demands for social justice and change. We can create today, in very undemocratic contexts, we can create the condition of success of public interest litigation, and this litigation can reintroduce politics, healthy politics, in the public debate, despite the previous skepticism we talked about. I thank you very much.
Thank you, Professor Hamram, for sharing with us lessons learned from working towards social justice in the legal agenda. Ladies and gentlemen, this concludes the 2020 Tang Prize Laureate Lecture in Rule of Law. Please do join us for the other 2 sessions of the lecture series, which will be posted also on the Tang Prize channel. Thank you and goodbye.